Welcome to the Building Doctor Show with Jens Johansson.
Okay. Welcome everybody to the Building Doctor Show. I am your host, Jens Johansson, and I'm glad to see you here today to learn more about your building. Today we're going to talk about claims and litigation and fighting and stuff, but we're going to talk about how to stay out of it and how to avoid it, how to dance around it, but when, not if, but when it hits, how it's not really that stressful and how we can help you walk through that. So today our guest is Jason Grosz, an attorney from the office of Weil Fotheringham out of Oregon. So Jason, say hello to the crowd.
All right. Hi, everybody. And thank you, Jens, for having me. I love that you found the single scariest picture of me that we have to talk about litigation today. It's so funny, our law firm pictures that they found the one picture of me not smiling or laughing.
It's your frown.
It's my frown. Yeah, exactly. My game face. So I'm Jason Grosz, and I'm a partner with VF Law, Weil Fotheringham, out of the Laco, Oregon office. And I represent condominium associations and homeowners associations for a living. I represent several hundred, all shapes and sizes, big steel and glass high rises, tiny 2, 3, 4, 10, 20 unit condos, master plan communities with clubhouses, golf courses, amenities, and everything in between, big or small. And I do both general counsel work and litigation. And on the litigation, go ahead. Yeah. I was just going to say, on the litigation side of things, I defend boards that get sued for various things, fair housing issues, architectural review disputes. I do some insurance coverage work when we have an insurance carrier that either doesn't want to cover a claim or isn't handling your claim the way they should be. And actually, where I met Jens was doing construction defect litigation. We've used Jens and his company as expert witnesses in those sorts of cases. So that's a little bit about me and my background.
Yeah, cool. Yeah, and again, it's not what the genesis of the show is about. Is there's lawsuits around associations and condos, and Jason, you brought up some of that. Of sometimes boards have to sue residents, sometimes residents sue boards, sometimes neighboring boards sue each other, sometimes master communities and what do you call the joint community, there's the master association, and then
master and sub associations.
Sub associations. And so we wanted to, I guess one of the things I see on my board clients' face is, oh no, I'm gonna get deposed, I don't know what to do, I'm freaking out. And it's like, it's okay, it's not as bad as you think it is, and it's not as scary as you think. And so we're Jason and I are here today to answer some of these questions about it, talk about some of the basic things of, discovery. What's discovery? What's attorney-client privilege? What's litigation versus claim? And so just everything around that, but also give you, some of the current trends we're seeing. And there's, when everybody realizes condominiums can be litigious, and we're just kind of seeing that rise a little bit. And so our goal here is to keep you out of trouble. And for attending live today, this is the live Q&A. So you get to ask us questions. So get those questions that you have started into the Q&A. First come, first serve. The chat box is used for more putting links in and things like that. And Ben, the producer, will help you do that. But while we're talking about this, we're going to run a little poll, see who's here. And let's see what's going on, who our audience is. What we like to do is tailor some of these things. And I am missing the poll button. Where is the poll button? Used to be polls. There we go. Separate poll, launch. There we go. Okay, it's in a little different place. So while that's running, we will go over to Disclaimers. As you know, there's 2 disclaimers on the show. First one, put away your credit card. We're not selling you anything. It's a free show. And so that dovetails into the second one. The disclaimer is this is educational content only. We are not giving you legal, financial, engineering advice. We're just kind of 2 dudes on the internet trying to help you out. We've worked with a lot of boards, and we've seen what worked and we've seen what didn't work. And so we want to help share that and in the hopes that it benefits you. So let's get back to.
I love it when someone other than me gets to give the disclaimers. That was great, Jens.
That's right. Gotta have disclaimers. Okay, let's go back to polls. Gotta find it again. Okay, we're gonna end the poll. We've got a lot of people out of Washington today. So
okay.
Jason, where are you registered? You're registered to practice law in Oregon, but VF has offices in Washington, Oregon, Arizona, Utah.
Yeah. We're a multi-state firm. I practice in Oregon and Washington. We have offices in Idaho and Arizona, Denver, Colorado, Arizona. We do work in New Mexico. We're all over the place. Western United
States. Cool.
But I'm Oregon and Washington.
Okay, excellent. So let's see some more poll results. I'm a board member. I'm a condo association resident. We're getting it from the newsletter. Have you been through a big repair project? Yes, 75% of you have been through a big one. So, okay, that's cool. We got board members and those who wanted to fill that out, I should say. So, okay, cool.
Well, maybe we should talk about repair projects a little bit too.
We've got countless episodes on repair projects. We're going to This is episode 21. We're approaching 2 years, and with the interest and the level of sharing and commenting and good questions, we think we're hitting a good spot. There's lots of good feedback on this. And that's also an important thing. Let's talk about you guys, the audience, are our marketing budget. So give us that 5-star review, give us a thumbs up, share it with your board, share it with your friends. But those good algorithms with the 5-star reviews and the shares really help encourage us to produce more, and B, help the algorithms help, push it out there. So you guys are the 5-star, or you guys are the marketing budget, I should say. If you want to leave a 1-star, just turn it off and go watch something else. So, but 5-star, you guys will help us. Anyway, stick around for the live Q&A at the end. We'll answer as many questions as we can. We try to stick to an hour, but we'll always roll over other questions. And then stay tuned. You'll see contact information for both Jason and I. If you have questions, Jason's agreed to answer your questions and take your calls, and I can do that too. So Ben, the producer, is monitoring the chat, and Jason and I will look into the Q&A panel at the end of the show. And we're also doing a little giveaway. Jason, you've got a little giveaway of swag of some sort. Is that true? Yeah, great. So we got 2 winners today. Okay, let's jump into the show. Here we go on the agenda. So today's agenda, like we kind of talked about, but how we're shaping this for you, claims and litigation process understanding, 2 different things. How to stay out of them, of course, some proactive things. Really understanding who makes decisions and how these decisions are documented and where they live. And then, ultimately you're going to have meetings. So how to control that town hall brawl, we call it. And then giving you some actual scenarios and pitfalls that we're seeing currently, and how you can just learn from others. So there's really about 4 or 5 things you need to do to stay 99% of the time out of trouble. And so your time is well invested today. Let's learn from others' mistakes, and we will help you through that. Okay. First thing, claims 101. Kind of understanding discovery. So, Jason, what's discovery mean in legal terms?
Well, the simplest way to explain it is after a lawsuit or it could be an arbitration, right? When we talk about litigation, that could be in court, with the ultimate end being a jury trial, or it could be in arbitration, using one of these private arbitration services like American Arbitration Association or Arbitration Service of Portland.
Mhm.
And the big difference between those two tracks is the folks that decide your case at the end of an arbitration are either an arbitrator who's sometimes they're retired judges, sometimes they're practicing attorneys, but that's the person, or if it's a large enough dispute, 3 people
Mhm.
that will decide your case. Whereas in a court, either a judge or a jury, or sometimes both, are going to decide your case. But in both of those tracks, there's a process called discovery. And simply put, that's where both sides learn about the other guy or gal's case.
Right.
And discovery takes a variety of forms, right? You mentioned depositions, right? Depositions are where one attorney gets to depose or interview on the record while a court reporter is taking down all the questions that are asked and all the answers that are provided, for a formal record.
Mhm.
That's one form of discovery. Another form of discovery is documentary discovery, right? We send what are called requests for production back and forth.
So that's a subpoena. Is that?
Well, subpoena is a little different.
Is
Subpoena
it?
is when you request records from a non-party to the litigation.
Oh, see, I learned something.
There you go. Yeah, and subpoena power, by the way, is the only real power that attorneys have, right? You file a lawsuit, you can send a subpoena to a third party that has information about the case. So, like, for example, I've had construction defect cases where I was suing a contractor and the owner of the contractor's company was deceased.
Mhm.
And the only person that had records was a former employee of a company that had been wound up, and the owner of that company was deceased. But this person had emails, or they had invoices, or they might have had a construction contract somewhere.
Gotcha.
And so I would send a subpoena to that third party. And when you get a subpoena, you really have to respond to that, because if you don't, you can be held in contempt of court. So that's the real power that attorneys have, subpoena power. You can also send a witness subpoena, right? So when we try a case, you may have somebody that isn't a plaintiff, the person bringing the suit, or a defendant, the person being sued, but they have testimony that is really important to prove your case. And so you can send a witness subpoena as well.
Okay.
So subpoenas are part of discovery. They could be for documents, they could be for testimony, they could be for both. Discovery, a lot of the documentary discovery these days is emails, electronic records, text messages. I assume we're going to talk about this, but your text messages are discoverable. And just because you deleted them from your phone, do not assume that they can't be gotten, because they can.
That's why every movie star involved in litigation loses their phone. Something happened.
Yeah.
Okay. Gotcha.
Well, but you can subpoena their cell phone carrier. So, I've had this happen where I've been taking somebody's deposition and I'm like, what's your phone number? And they answer the question and I say, is that a landline or a cell phone? 98% of the time it's a cell phone.
Gotcha.
Do you
Okay.
have-
So as far as, I don't want to get too far into the weeds, but discovery is really part of litigation. It's not part of insurance claim. And so that's one of the big differences. In the next slide, we'll get into a little bit of definition, but if we're mad at the contractor and we're the board and we want the contractor to come back and fix, and we've hired Jason and his firm to be a lawyer and write him a mean letter, we don't get to do subpoena and depositions until we file a lawsuit, correct?
That's right.
Right. So if it stays in this insurance claim business or insurance claim, it's just a claim against their insurance policy, just like your car accident would be. I've got
an important caveat there, though. So
Okay.
when you open up a claim with your insurance company, your insurance agreement's just a contract between you and the insurance company. It could be a property insurance policy, it could be a liability insurance policy, whatever. But the insured has a duty to cooperate with the insurer, the insurance company, in evaluating and investigating the claim. So for example, if you have a multi-unit water loss, and the insurance adjuster is doing their thing to figure out who's responsible in what part for the loss, you as a condo board member have an obligation to cooperate with the insurance adjuster. And if they request certain records, you've got to provide those records. So
Gotcha.
just
So
a clarification.
kind of like a subpoena, but it's more of a contract obligation.
Yeah. Well, and the risk is if you don't cooperate, they could deny coverage.
Bingo. Okay, so let's stay on this slide. So discovery is a stage of litigation. So if you're not in litigation, and we'll get to those definitions, you don't get their documents from. Well, I can't because you can't. So there's pros and cons. You can't, and so kind of defining those blocks. But what's attorney-client privilege when I'm working with boards and they say, well, I've got this privilege. I've got this attorney-client privilege. What is that? Explain.
Well, so attorney-client privilege is an evidentiary rule that protects the client from having confidential communications with their lawyer being introduced to prove that they were liable at trial. Gotcha. So the easiest example of this is Law and Order, right? Or Better Call Saul, or whatever your favorite, crime drama legal show is. When Saul Goodman goes into the little breakout room with his client that got caught, selling methamphetamine or stealing a car or whatever, the client can speak frankly with Saul Goodman or, whoever the attorney is, and get advice. And that advice is not discoverable and it's not admissible at trial. So the other side doesn't get to hear the advice that you give your client or that you as the client, solicit from your attorney. It gets a little more complicated when you're talking about a condominium association because condominium associations are corporations. They're not, there's the myth of corporate personhood, but they're not people. It's not like, I'm your client, you're trying to get me out of this, stealing a car charge. So in a corporation, the attorney-client privilege generally runs between the attorney and the board, and the manager, as a managing agent of the association, is swept up in that privilege. So the manager can hear the advice without waiving the privilege.
Right. So the manager has some kind of fiduciary duty to the board, and so they're kind of acting as is that what pulls it in, or is it?
Well, it's a contractual
agent.
Yeah, it's an agency relationship, and let's not get into whether it's a fiduciary relationship or not because it's contractual, but the manager is swept up in the attorney-client privilege. And why that matters is because you can waive the privilege if privileged advice is communicated to some third party, right? So Jens is my client and I'm his lawyer, and I write him an opinion letter saying this person that's suing you on a fair housing claim, the claim's pretty strong in these 3 parts, it's weak in these other 3 parts. Well, if you take that letter, which is a privileged communication, and then you share it with your neighbor that's not on the board, then the homeowner that's suing the association could argue that the privilege is waived. And once it's waived, arguably all the advice that I provide Jens could be discovered by the third party that's suing the association. So it's important to preserve the privilege and not communicate privileged advice to a third party, because and the policy behind this is we want people in our legal system to have access to good advice, and we want people to be able to discuss whatever the problem is frankly with their lawyer. We want people to have good legal representation. But in a condo board context, we use things like executive session to preserve the attorney-client privilege. So, if I'm defending the HOA in this fair housing claim, and the homeowner that's suing the HOA comes to a meeting and is insisting on, a particular parking space, right? I need a handicap space, I have a mobility impairment, and there's a lawsuit going on. And by the way, it's not just the attorney-client privilege doesn't just trigger after the lawsuit is filed. It's also in anticipation of litigation. So if you suspect that a lawsuit is going to be filed, the privilege kicks in then. So if, the attorney gives you advice a month before the lawsuit's filed, but you've already received a demand letter, the privilege kicks in, before the lawsuit is filed.
Right. So I wanted to bring that up specifically when we in a consulting role are meeting with you, the board, and your attorney, maybe your manager's there, maybe they're not. We understand as a consultant that you have attorney-client privilege with your lawyer. And so there's portions of meetings where do you want us to leave the table and stand outside because this is privileged information. And rolling into that second bullet, don't send us privileged emails. Hey, I'm forwarding on an email to you from the attorney so you can see what they said. You've just broken the attorney-client privilege. So as board members, really respect that and understand what that attorney-client privilege is, and ask your attorney about it. How do you want to handle this? How do you want to do this? And after working with so many of them, they're just like, don't use email, don't use text, call me.
And
call me.
That's more important in Washington than Oregon, by the way, because in Oregon we have trial by ambush, and there's actually an expert witness privilege. We don't have to do expert discovery, but in Washington, you do have to do expert disclosure. So if Jen's got a bunch of privileged emails in his file from the attorney, there's a risk that you just waive the privilege.
Right. So moving on, the meeting minutes and historical files full of proposals and reports. Here's what I mean by that. Your meeting minutes are a documentation of the meetings, and they're a document, and they're minutes, not hours. And so we just have a quick summary of this was voted on, this was approved, this was done, this was discussed, and this is tabled, this is pushed to there, decision goes here, done. It's not a big written, diatribe about what happened. But then you also, that's where it's recorded. And so the other side is going to be looking into that discovery. You guys have been talking about this for 3 years. It's in your meeting minutes. Why, you can't say you just found out about this. And so be cognizant of what you put into your meeting minutes, but then also understand what's in your file, because if it gets subpoenaed or a document share, between the other side, well, you've been talking about this leaky roof for the past 10 years. And actually you've got roof bids from 9 years ago and 8 years ago and 7 years ago. Why did you get a bid if you didn't think you were going to do the work? You thought you were going to do the work, so you went and got a bid, but you never signed it. Why didn't you sign it? Well, we didn't have the money. Okay, there's a reason. So there's a story. So watch out for that historical file full of these things, because then we get into some timing, and so that's another piece of you've known about this for how many years, and some statute of limitations or some tolling things have already run, and so just be careful about what is in your file, not just a big shoebox full of random things and notes and things. Make sure your file is clean. Make sure it's accurate. That comes down to the bottom bullet. Consider having a retention policy. We talked to a lot of boards and I said, don't we have to save things forever? Well, no, it's up to you. So now, Jason, what's your lawyer perspective on a retention policy of,
I think it's a good thing to have. What I was going to say, this is just kind of a practical pointer, but minutes are the corporate record of the decisions that the association made. And what Jen said is exactly right. Minutes should be minutes. They're not hours. Who was at the meeting? What motions were made? Record whether the motion passed or not. But minutes are often one of the most important exhibits in a lot of cases that an association would get involved in. Mm-hmm. And when I'm sitting next to a condo board member that's being deposed, doesn't matter whether it's a construction case or whether it's an owner suing the HOA or whether it's the association suing an owner for some rules violation issue, oftentimes the opposing attorney trots out the meeting minutes and says, hey, look, I see right here that you were at this meeting. Can you tell me about this discussion point? Well, here's the thing about minutes. You have a lot of control over what goes into those minutes, right? You got to record the decisions, but you don't need to record every single discussion point that's made. Mm-hmm. And You certainly don't want to record anything that's discussed in executive session because you run the risk of waiving privilege. So I have a lot of associations when there's a pretty nasty piece of litigation, you know, the secretary takes the minutes, they're not approved until the next meeting the following month. A lot of my clients send me the minutes and are like, Jason, are you okay with what we said here? Are we waiving privilege? And I say, no, this is good. But you have some control over what goes into those minutes. You got to document the decisions, you got to document who's there, but you have some control. The retention policy, you're going to get different answers from different lawyers about this. I'll just tell you what I think. So it is great to have a records policy, and a records policy is actually broader than a retention policy, because you will have owners that for whatever reason make repeated and voluminous requests for records. And we're seeing a lot of this right now. You have an owner, they don't like that you didn't approve their architectural review application, or they're aggrieved because you didn't give them the parking spot they asked for. And one of the leverage points that they use is they torment the manager or the board members by making, they ask for the last, 10 years worth of minutes, or every contract between the association and any landscaping company. I just had this in a case where the whole dispute was over landscaping. And you not only want to have a rule about how long you keep records, but you want to have a rule over who pays for gathering the records and producing them.
Yep.
Because it creates an incentive for an owner that's making these voluminous records requests, really just to harass or annoy you, not because they have an earnest interest in seeing the records. If they got to pay for it, they're only going to ask for the stuff that they really want to see. And it's going to save you managers a lot of time and you board members a lot of heartache. So I think you should have a retention policy, but you should also have a records inspection policy. And I just kind of do the two as one.
Gotcha.
In terms of keeping records, the minutes, I would say keep those forever. If you have as-built construction plans, or even if you just have permit plans, keep those forever. Because Jens, how often does a client say, hey, we have a 40-year-old condo, we have deferred maintenance, and you're like, well, do you have any plans? And they usually don't, but that would be helpful to you. I'm just guessing.
Super helpful. And it's just, absolutely. And it's, thanks for clarifying on the retention and the records. There's some things that, you really want to keep a lot of, and I'm not advocating throwing things away to hide. I'm actually advocating the other thing of, you do want, we did talk about this. Here was the decision at the time. We elected not to pursue that. Here's why. It shows reasonable business decisions that a group is making, or we got an opinion from so-and-so. We consider this dead. We consider it put to bed for a couple of years. This is why why didn't you work on that? Well, here's exactly why. And so really supports your position. And
financial stuff you're supposed to keep for 7 years. I have a lot of clients that keep it for 10 and some that keep it forever. That's really more of a CPA question, but 7 years, I believe, is a safe rule of thumb. And, policies, board policies, you should keep those forever or until they're superseded by a future policy.
Change. Yeah. And so the other comment there, emails and inboxes and phones, just our tip there is consider a board account versus your personal account. It's just, I'm going to conduct board activity through president at, Leaky Towers.
Condo, HOA.com.
At gmail.com. And that way you can, it's also a choice too. I can choose to go into my business of running the board, and I'm not getting pinged by all these board questions when I'm looking at my personal email or at work or whatever. And if there is a discovery thing, sometimes that inbox is subpoenaed, and now they have all my life as well as my board activities. So
also, don't use reply all, use BCC. I can't tell you, Jens, I was doing a large deferred maintenance repair project with one of your clients. You didn't work on it. Your colleague, Ryan Paddock, worked on it. And this community had about 40 homeowners, and there was a board recall, and the instigator of the board recall because they were using reply all email, he had the email addresses for everybody in the HOA, and he was filling up people's inboxes with 2, 3, 6 venomous emails a day.
Right.
Use BCC.
Right.
It'll save you a lot of heartache.
Good tip. All right, let's get on to the next one here. So definitions, we kind of talked about this. We talk about this kind of in claim versus litigation, and claim can be an insurance claim. It can be an allegation or issue that may become litigation. But right now it's look, two parties are coming together and they're trying to figure this out. And maybe there's an insurance policy that'll help them. And maybe, don't sue me. We don't have to go that far. We can work through
complaint. This. Could also be a bully complaint, like a fair housing type issue. There are some state agencies that administer those. That's another type of claim.
Complaint. Okay. Yep. And so then litigation or lawsuit, and that's really triggered by filing paperwork with the courts, right?
Or one of these arbitration services. Yeah.
Yeah. So is arbitration litigation?
Yes.
Yes. Okay, great.
It's just not in court. It's in a private venue. Yeah.
Okay. So why we have that in there is that, we'll be working with an association. Both parties are trying to work things out. And you'll get the rumor mill going of, well, I can't sell while this litigation is going on, or I can't possibly refinance while this litigation is going on. And that's just not true. We're not even in litigation. And so, it helps explain that and helps talk about those things. And like we said before, well, just go depose them. Well, I can't, because we're not in litigation. And so we're trying to work our way through this. And so there's pros and cons to both, but just understanding the difference between the two.
Well, and where this comes up the most for managers and self-managed boards is when you get a lender questionnaire, right?
Right.
Somebody's buying a condo unit and they're getting a purchase money mortgage to buy their condo unit. And the lender sends you managers a questionnaire. Some of you guys use a service called Condo Certs. There are a few of them out there. And they send a list of questions. And one of the and they vary ever so slightly from lender to lender. But one of the questions is there a pending or threatened special assessment? Yes,
right.
No, see attached. Then another one of the questions is there pending litigation? But sometimes it's not, is there pending litigation? It's, is there pending or threatened litigation? So a lot of times you managers call me and we're in this sort of interstitial area between when we know we got an owner that's really angry and they have a lawyer and they sent us a demand letter, but they haven't actually filed a lawsuit yet.
Right.
Intervening period is very confusing for you managers, because you guys call me. You probably don't call Jens for this, but you call me and you're like, well, Jason, which box do we check?
Right.
And I always err on the side of over disclosing for two reasons. One, because you want to be truthful, but two, if that owner purchases that condo unit and the seller didn't disclose this pending litigation to them, and you didn't check the box, then the person that buys that condo unit is going to show up to a meeting 3 months, 6 months, a year later and be like, why didn't anybody tell me about this?
This has been going on. We knew here's the report date. It's in your meeting minutes. It's in your, and then they have a case, and we're seeing lots of that.
So I usually say, if it says pending or threatened, say yes.
Mm-hmm.
If it just says pending, then and there's no lawsuit filed, the answer is no. But I usually encourage my clients to write a little C attached. And sometimes I write this for them. I just say, and I don't name names, I just say association has received a threat of a housing discrimination lawsuit by an owner. Mm-hmm. We anticipate that this claim will be defended by insurance. Something like that is truthful, will satisfy the lender. And a year from now, if the owner's like, well, you didn't tell me anything about this, then you can say with clear eyes, we checked the box.
Right. We told you loud and clear. Yeah. So then the insurance coverage side of things, D&O, I think everybody's aware of that. Directors and officers, that's the board policy. Master policy is the, condo association policy that deals with kind of everything: wind, fire, storm, earthquake.
You want
whatever.
me to give the 90-second rundown on the types of
No, because we're tight on time, so I don't have 90 seconds.
Okay.
Save that
Fair
for
enough.
a question. If you guys want a Q&A from those things.
This is what happens when you invite a lawyer on. It's a
I know. It's like, stop talking. Okay.
Okay.
Yeah. And then how does an umbrella policy weigh in for a board or weigh in for a unit owner? How does because a lot of people have umbrella policies, but we kind of think it's like, well, it ties to our car and our home and or whatever. Have you seen umbrella policy for liability claims?
All the time.
Oh, okay.
Umbrella policies, sometimes referred to as excess policies, are a type of insurance that protects you over and above the insurable limits of your underlying liability or D&O policy. So if you have $1 million liability policy per occurrence and you get sued for $10 million and you have a $5 million umbrella or excess policy, your $1 million liability insurance policy will hire a lawyer to defend you, assuming it's covered, and pay up to the covered limits of the $1 million policy, at which point, once the underlying policy has been exhausted, the umbrella coverage will kick in and cover $1,001 to $5 million. That's how it works. And these are great to have. All my big associations have them, just about all of them.
Yeah.
A lot of small associations don't have them because they're like, no one would ever sue us for more than $1 million. But umbrella coverage is relatively inexpensive.
Right. Very inexpensive.
Because it doesn't kick in until you've exhausted the underlying policy. So it's a lot of bang for the buck in terms of protection. Umbrella policies do not protect you over and above your property insurance or master policy. That's a different thing. It's umbrellas apply to liability.
Gotcha.
Okay, I'll shut up now, Jen. Sorry.
So the D&O, I'm surprised by how many boards do not carry D&O or other type of board specific insurance. And it's just a cost issue, or they didn't know they needed it. They just weren't aware. But it's directors and officers, and it protects you as a board member conducting board business.
It protects you in your decision-making capacity on behalf of the association.
Yes.
And when I get a call from a client, particularly self-managed clients, I go through a little checklist. Do you have D&O insurance? Do you have master policy? Do you have liability? Occasionally, I have a self-managed association call and say, what's D&O? And I say, well, send me your insurance certificate. They do. They don't have D&O. I say, look, I'd love to do your legal work, but hang up, call your insurance agent, buy D&O, and once you have D&O, call me back, because your money's better spent on D&O than it is on Jason. And I mean, it's that important, right? Because D&O is one of the things that protects you directors in your individual capacity from personal liability.
There you go.
I would not serve on a condo board that I knew didn't have D&O, because I want to make sure that if I do get sued, I'm going to have a defense and insurance coverage. So D&O is critical.
Yep. Okay. Perfect. So we talked a little bit about the disclosure. That first bullet, and it dovetails into the next slide, is who is responsible for making decisions and how are they documented? And I know you have this next slide. This is a matrix that you put together. But what we're getting at there is who's responsible for making the decisions. And 95% of the time, isn't it the board? The board is elected by the association to conduct business according to the community's rules and bylaws and things like that. And so we see a little bit of this of, we didn't know we had to make that decision, or can our manager make that decision for us? Can our lawyer or our consultant, they told us what to do. No, time out. We're giving you advice. You guys are the ones that need to make the decision. And so how do I make that clearer? And maybe you can clean that up in the next slide. But why is it fundamental that this is a first bullet point on this slide to you?
Well, so it's fundamental because a lot of times, whether it's litigation or a repair project or whatever it is, there's an argument about from the owners, why don't I get to make this decision? Why do you board members get to impose a $25,000 special assessment on me? The owner should vote on that.
Right.
A lot of people buy in condos and they have a fundamental misunderstanding of who gets to make what decisions. So the basic rule, this is in Oregon and Washington, is that the owners elect a board.
Mm-hmm.
And so that's an owner decision who gets to serve on the board. You may not show up to the annual meeting, you may not vote, but the people that do show up get to pick who serves on that board. And then that board is empowered. They have the power and duty to make all of the decisions on behalf of the association, except for a handful of really important, really basic decisions that are reserved for an owner vote. And that reservation for an owner vote will either be in the RCW, like waiving
Washington's rules. Mm-hmm.
Yeah, revised code of Washington, like, for example, waiving your financial audit requirement or a budget ratification. Those are typical Washington examples, or amending the governing documents.
Okay.
So the owner vote requirement will either be in the statutes or in your governing documents. So, typical things that take an owner authorizing vote would be changing the rules of the organization, amending your condo declaration or your bylaws, typically takes an owner vote.
Mm-hmm.
Doing a capital improvement, right? Jens lives in a condo. He wants to build a rooftop jacuzzi for the owners to use. That often takes a vote of the owners, because you're spending the association's reserve funds not on maintenance, repair, and replacement, but on Jens's rooftop jacuzzi. And the owners got to approve that, because they were paying into the reserve fund. Jens, you're being a good sport, thinking that was going to go to maintenance repair, not Jens jacuzzi. So,
adding a tennis court or
adding it or pickleball, because I hear the kids love pickleball these days.
Right.
So, but I have lots of clients right now where tennis courts are being converted to pickleball courts, and it's the source of huge controversy.
Oh, I didn't think about that.
I won't go down that rabbit hole, but
okay.
Yeah, so identifying who gets to make what decisions is super important. In litigation, some associations have a poison pill provision that says that the board cannot hire an attorney to sue somebody or sign a contingent fee agreement for a claim in excess of $100,000 unless you get a vote of the owners. I've seen that provision.
And that's poison pill, meaning written into the bylaws by the original developer before there was even a board. And
it prevents the developer from getting sued later on.
Correct. And so
there's all kinds of litigation around the country about whether that's even enforceable, but I do see that. And that's an example of a reservation in the governing documents requiring an owner vote. So particularly in these large special assessment loan deferred maintenance projects, the first thing you do is you have somebody analyze who gets to make what decisions, because you can bet that when you get to that meeting where you're talking about the special assessment and it's a lot of money and people are stressed out, you can bet that an owner is going to say, board, why do you get to make that decision?
Correct.
Why aren't we having an owner vote? And you better know the answer to that question before you get to that meeting. And even better than that, it's nice to have a letter from an attorney saying, when the owner stands up and says, well, why aren't we voting? You can say, well, we got an opinion from Jason or from our attorney, and we're happy to share the opinion with you. And by the way, there's no threat in litigation. So you're not waiving the privilege when you share that opinion.
Bingo. So let's see. We'll get to that slide. A couple more things I wanted to cover on disclosure rules. Every state's different. Talk to your attorney. Make sure what Jason's saying is correct for the state rules. The transaction disclosure, we talked about that of the association was dealing with this building investigation process for 3 years, and somebody just bought and sold, and the seller had no idea that this was going on. The board knew that, but they didn't tell the association. So the seller, when they're filling out their Form 17 disclosure, they didn't know about anything coming up. And then, people who just buy in are mad because why did I wouldn't have bought here with this big assessment pending had I known. But then the other side of the disclosure, the timer is always ticking. And so most insurance policies and or statutes and limitations have a 1 or 2 year timer. And so what happens is we'll give our report saying your decks are falling off, and the board will maybe fight and argue, and a new board, and then they're still arguing, and all of a sudden they dilly-dally their way beyond the 1 year or the 2 year, and they call us back and say, hey, remember that report you wrote back in 2020? We'd like to pursue an insurance claim. And we kind of go, well, we're not miracle workers, and neither is Jason, but talk to him and see if your timer is expired. But I think you've passed that limit. And so it's the same kind of thing with the 4-year Condo Act in Washington. 4 years and 1 day, you don't get any of that warranty, or the 10-year in Oregon, and so on.
These are hard deadlines. Yeah.
Attention to these deadlines. And so disclosure and deadlines. So anyway, let's get on to that next one. So this is your slide. I'm turning you loose. You're talking about, here's the decisions that you have to do. And so you're citing some Oregon rules, ORS.
Yeah, and there are parallel sites in the RCW, and it just depends whether you're an old Condo Act, new Condo Act, or new Condo Act, HOA, which all the Washington managers are intimately familiar with. But
spell that, yeah.
But yeah, this is, what I was talking about. The basic rule is the owners elect the board. The board gets to make all the decisions except for a handful of ones. But this slide is from a presentation I teach on how to successfully conduct a large repair project that involves a special assessment and a loan. And I know we have several people on the line that have experience with this, but the decisions. So what I like to do is I like to write a letter, and I say, here are the decisions that you're going to have to make. You're going to have to pick a scope of work, right? Is it maintenance, repair, and replacement, or is it a capital improvement like Jen's jacuzzi? Is it establish a budget, right? And in Washington, you have budget ratification. We don't have that in Oregon. In Oregon, the budgetary decision is almost always a board decision. Imposing the special assessment or serial assessment. Borrowing money from a bank sometimes takes a vote of the owners. Assigning
the
a
association borrow money. Yeah. That's a little bit different. Yeah.
Yeah. So the decision to borrow money from a third party in some associations triggers an owner vote. So I write a letter and I say, these are the decisions that I anticipate you'll have to make. And I say board decision or owner vote. And if it's owner vote, I say whatever the threshold is, 75% of all owners, 75% of the owners in person or by proxy at a meeting. And we just kind of go down the line, and then you got an opinion letter that you can share with an owner when an owner says, well, who gets to make what decisions? And as I do more and more of those projects, and I'm sure you have some very good lawyers in the Seattle area that have done as many of these as me, but I've probably done more of these than anybody in Oregon. The more I realize that identifying that issue on the front end is important, because there's nothing worse than getting all the way to the point where you're about to close the loan or you're about to sign the construction contract, and then you call the lawyer and I'm like, geez, I'd love to close that loan for you, but have you had the owners vote on this yet? And then your project set back 3 months. You don't want to be there. You want to know the answer to these questions on the front end. We've
had it on the other side where the owner, where one resident comes back and says, you guys didn't have the authority to impose this $50,000 assessment on me. I'm not paying. And then
I have that case.
And 25% of the owners all of a sudden, sweet, we don't have to pay. Thanks. It's because you didn't have a vote.
I had a case where we were about to start a construction project and the board had adopted the special assessment, and an owner filed a lawsuit seeking a court order to stop work because he said it was a capital improvement, 40-year-old siding, swapped out for 2015 hardy plank, and he said that's a capital improvement, and he asked the court for a court order stopping work. And we eventually won that case, but we spun around for a while, and we probably could have averted that if we had done enough work on the front end.
Yep. There's We've been involved in a few of those, helping the court determine, is this maintenance and repair or is this a capital improvement? And so very interesting. And yeah, that scope
Well,
of work.
Washington has better law on that than Oregon, actually. And the reason Washington has better law is because in this case I had, the guy that sued us and lost failed to post his appellate bond. Otherwise, we'd have an appeals court case on this in Oregon. But in Washington, you do have case law on what is and isn't a capital improvement, and it's better than Oregon's.
Yeah. Yeah. So really important to understand that, get that opinion letter up and have somebody go through the documents and just really understand that. And we'll talk a little bit in more slides about that voting percentage, because it's this kind of vote. So it's a majority. This kind of vote, it's 86% or something, or 100% unanimous. So yeah, good to know. So let's see, understanding. So this slide was just, people get, board members especially get freaked out about, oh my God, I'm going to be deposed tomorrow.
Yeah.
And I just smile. I've been deposed a ton of times. And I just say, look, it's just a recorded conversation in a conference room. And these days it's a Zoom call. It's just like what we're doing here today. This Zoom call is being recorded. But all the point of the questions is just, you're just answering questions. What did you do and why did you do that? And so it's never as juicy as the movies. The movies have to make it juicy somehow so you wouldn't fall asleep in it. And, being in depositions, I'll have 10 attorneys waiting to ask me questions. I've had attorneys sleeping. The other attorneys waiting to answer questions, they've fallen asleep in the deposition.
Or playing Tetris.
It's that exciting. Yeah, exactly. And so you as a board member, as long as you have nothing to hide, it's not painful. It's just, hey, look, we had this meeting on this date. Here's the meeting minutes. Here we talked about it. Why did you do that? Well, my consultant told me to do this, and we voted on it, and it was unanimous board vote. This is exactly why we did what we did. And so very actually easy to get, kind of through, if you will. But think conference room. So then mediation, 98.5% of these, whatever the stat is, of these condo cases get resolved in mediation. They don't go all the way to trial, kind of thing. Mediations are, again, done in a conference room with a mediator. And all the mediator is I am a person here to get both sides to agree to a deal. Oftentimes they're a lawyer. Oftentimes they've had mediation training, which is basically negotiation training. But again, it's not a big, scary thing. And it's actually a process to it. And there's a process to getting this disagreement resolved, and we're going to get it resolved. Arbitration, this is where the arbitrator makes the decision. But again, most are in a conference room, some are in court. But I mean, would you add anything to these, Jason, as far as kind of where they take place, how stressful they are, what, here's, it's just a process. It's a guy in a suit that helps me figure this out.
Well, so depositions, I agree with most of what you said, although, I've had clients be very anxious about having their deposition taken.
Yes.
And the way you manage that anxiety is with preparation. And
Correct.
so before you go into that room and the attorney representing the angriest owner in your association that's suing you, before that attorney is asking you questions, and it's in a conference room, the attorney's on, or it's over Zoom, the attorney's on one side of the table, I'm your lawyer, I'm sitting next to you on the other side of the table, occasionally objecting if the lawyer asks for something that's privileged. Or, totally, beyond the pale, but you practice, right? Like a good lawyer, like I'm thinking about the kind of stuff that the other guy's going to ask you. And I'm thinking about what the worst parts of your case are. And I'm anticipating that the other lawyer is going to ask you about them. And so often, you do deposition prep and, you talk about things like, if you don't know the answer, it's okay to say you don't know the answer. If you don't remember, it's okay to say you don't remember. It's better to say you don't remember than to say, well, I think it was this, but I'm not sure. Right. So you do prep, right? But generally speaking, Jens is exactly right. It's way less dramatic than in the movies. It's often pretty routine. Mediation is just where both sides agree to have a neutral third party attempt to resolve the dispute. And arbitration is like a trial. that occurs in a lawyer's conference room, or during the COVID days, we did it over Zoom.
Mhm.
But it's less formal than being in a courtroom, both in terms of the way the evidence is marshaled, and because there's no jury sitting there. Like in a jury trial, the lawyer's got to argue about whether something's admissible. The judge may say, hey, jury, step out, and then we argue about it, and the judge decides whether they can hear it or not, and then they get invited back in. Arbitration, I have some clients that hate arbitration, but the truth is arbitration is usually a lot faster.
Right.
And then trial, we've talked about that already, but
Mhm.
that's really all I would add, Jens.
Yeah. And I think, like you said, prepping the witness, and we can help our boards with training as well. Just, here's what to think about. Here's some questions we see. Every case has bad facts. And so here's the bad facts. If I were them, I'd be asking about them. So how do we walk our way through this? And here's how we can talk. So to help you as the board get comfortable, and just, it's one step, it's one bus stop along the route. And how much of the time is the board deposed? I mean, is it 50%, 40%?
Less. Yeah.
So that's what experts get. So experts get deposed. We'll do the deposing for you. So anyway, all right. Next one, staying out of trouble. And so these are just kind of my quick bullets. Follow the rules and the bylaws, including notices and timing issues. And we've talked, giving you examples about this of, you didn't conduct that vote right, so you can't assess me. Or you just called this meeting out of the blue, but actually meetings require 3 weeks notice and time, 60 days and this and that. Follow your rules, and a good manager is helping you do that. Act reasonable, that business reasonableness of the volunteer board member. I'm listening to advice. Nobody expects you to be a lawyer or a contractor or a consultant. But you do need to listen to them. If they've given you written advice and you ignore it, then of course you're kind of operating outside of that. Communicate and share. This, don't hide. I cringe when I talk to boards and they say, well, we don't have to tell people this. And I was like, it's not that you don't have to. Share the stuff, share it. Hey, we're working on this. We don't have the answer yet. We're trying. Here's what we're going through. There's a process. It's going to take 6 months, but here's the initial results of our investigation. Here's the report that we got. We're giving this out to, or talk to your attorney about what gets disclosed, but communicate and share is usually the better route.
The longer you wait to tear the Band-Aid off, the more it hurts. And so when you're delivering news to your owners, and by you, I'm assuming that you're a manager or you're a condo board member, the longer you wait to deliver bad news, the more likely it is that in addition to being upset about the bad news, the owners are going to feel like there was some effort to conceal the bad news, even if there wasn't. And so the longer I do this, and this is especially true for these special assessment deferred maintenance projects, I tell my clients, look, maybe you got a report, but you don't have a bid yet. Invite the consultant, invite me to a meeting to talk to the owners about it. It's okay to say that you don't have all of the information. What the owners want to hear is that you're working towards a solution. But the longer you wait to tell people, that generally speaking, the angrier they are going to be.
There's a good phrase. Conflict deferred is conflict magnified.
There you go. That's a good one.
Yeah, just talk about it. Next one, take the high ground as much as you want to clap back. I mean, it's just this, clapping back and arguing and fighting only pours gas on the fire. You will find the community supporting you. They understand you're taking a few arrows. That's the job of the board. They're supposed to be able to have a thick enough skin to be able to do that. They're not going to let you, take withering fire. But try to just be positive. And I know that everybody has a capacity for that. But as much as you can do that, do that. Have your lawyer manager involved, even if not in a claim. Why is the lawyer here? There's no lawsuit. Well, we just want to make sure we're doing it right and not ending up in a staying out of trouble is better than having
An ounce of prevention is much less expensive than a pound of cure. That's another good reason.
Let's keep from needing to save the day versus saving the day. Let's keep from needing to save the day. We're working way ahead of this and staying out of trouble. Okay, I notice we're pushing up on an hour here, but we are covering some good stuff, and we are seeing Q&As popping into the thing. But Jason has agreed to, answer any further questions you have, and his email and phone number are found here. Phone is 503-684-4111. Reach out to him. He'd be happy to talk to you. So let's commit to covering the next couple of slides pretty quickly, but they're up on the screen. You can take a screenshot of them. But now we're going to talk about the town hall brawl and kind of a before and during. And so this town hall brawl is, the mean meeting and everybody's yelling and all this stuff. But the before ideas is, again, back to this communication thing. Communicate with lots of town halls before a vote. And maybe it's not necessarily town hall meetings, but what we mean by town hall meeting is not a special required call meeting. It's you're telling people we're going to have a meeting on Friday night at the thing, and we're going to talk about the thing. No vote's going to happen there. It's not an official meeting. It's just come learn about it.
But you have to send a notice as an open meetings requirement. It's official in that everyone's invited.
Correct. But it's not. There's no votes here. Where we see people, and it's human nature to, don't surprise anyone with a vote. It's human nature to dig our heels in if we don't quite understand this, and I'm supposed to vote on this in 10 seconds. I just read it. I'm going to say no. So, consider a door knocking or coffee hour campaign, and just, hey, I'm gonna be out there on Friday afternoon on the sport court with a pot of coffee or a box of Starbucks, and come on down and let's chat. And I can answer your questions, so people can start getting this marinating process going of, I know it's coming, we got to deal with it, and sharing information, distributing information via all channels. We hear this. Didn't you get the email? No, you've got my wrong email, and you've never had my email right. Okay, so mail, email, text. I really love the old high vis yellow flyers that are taped to the front door. Maybe that doesn't work in your association or not, but look, we know you got the flyer. We know you got it because it was taped to your door. Don't tell me you didn't. Okay. So just really old school. Remember when we used to get pizza flyers under our windshield at the stadium park, that kind of thing. So I had to take it off to drive. Where else can I, put them up in the elevator, put them up in wherever the common elements are. Just understanding that you the board have been working on this for months. And so many residents are hearing about it for the first time. Understand that they'll be anxious and they need to process it. Understand that the filibustering technique, and what I mean by that is, we need more time. We need another meeting. We need more information. We need this. We need that. Just understand that. So I'm going to be sending out the information. We're going to be having lots of town halls. We're going to be doing this. And that way it'll kind of help those things. Do you have anything to add to the before to prevent the town hall brawl?
Well, lots, but I'll keep it short. So when this is especially true for special assessment projects, but it's also true for litigation. So when you present your typical homeowner with some bad news, a big bill, $25,000 special assessment, people go through something like the stages of grieving.
All stages.
There's anger, denial, bargaining. My brother-in-law could do it for less. And eventually you get to acceptance and the ability to act. And what you're trying to do with all of this communication, both before, during, and after the town hall, is you're trying to bring enough people in your community from anger and denial to acceptance and the ability to act.
Yep.
You're never going to bring 100% of people all the way there. You should let that go. You got to get a critical mass in your association to acceptance and the ability to act. And the best way to do that is to have lots of meetings and lots of communication. In the actual town hall brawl, this filibuster comment that Jen's made, I always like to end a town hall by thanking the board and reminding the owners, these board members are homeowners too. They're volunteers. They don't get paid to be here. And in fact, they're going to have to pay the same special assessment that you are. So when you see them in the neighborhood, go easy on them.
Yeah.
And then the other thing I always do when I wrap up that meeting, I thank them, and, sometimes people clap. The other thing I like to do is I like to say, this is not the last meeting. It's not the last meeting I'm going to be at. It's not the last meeting Jens is going to be at. If you didn't get your question answered tonight, we'll be at another meeting, sleep on it. We'll answer your question later on. Because people want to feel like they got a chance to be heard and like their questions and their input is important.
Yep.
And you're diffusing some of the angst about like, well, I didn't, the meeting started at 6:30 and it ended at 9:30, but I didn't get to ask my question. You're diffusing some of that, and you're giving folks an opportunity to ask questions at a later date. So those are kind of my footnotes, Jens.
Yep. So the ability to ask questions, and that's that be seen, be heard. I feel that I've felt seen, I've felt heard, and that's what those open, town hall meetings are. Now,
but
let's go.
You can't let that one guy who's got
Correct.
a million questions walk all over you for 20 minutes while 10 of his neighbors don't get an opportunity to ask their questions.
Correct.
And I have some techniques for that.
Yeah. And so now we're going to go to the voting meeting, and we have to. So this is during the town hall meeting. So how do we control? We've done 5 of these. We have one angry person, or kind of strategies to control. And just going down have an agenda and stick to it. Here's the 3 things we're covering at this meeting tonight. Well, what about it? Nope. We're going to have a special meeting for that thing later. Tonight we're going to cover this agenda. Next, we've got this allotted time for feedback, but we're going to have a sign-up sheet and a timer. You get 3 minutes. So there's 15 minutes for this. So that means 5 people, maybe 6, maybe 7, if you don't use your full 3 minutes. But I'm sorry, we got to move on. We got to stay on that agenda. And then getting into, it's interesting on the owners versus tenants versus media versus who's allowed into these meetings. I've seen media. I've seen, all sorts of, that person's not even an owner. They rent. Why are they here disturbing this meeting? And so have that ability to, as they're entering the meeting, what unit are you in? Who are you? You're not on this thing. You can't come in.
And you do that with a sign-in sheet that you identify people as they're signing in. Yep. And if it's someone's brother-in-law that doesn't even live there, you say politely, this is a private meeting. Do you own a home here?
Yeah, exactly. So it's all those other, YouTubers, etc. Understanding Robert's rules and how to run a meeting, maybe having a meeting runner or what do you call them? Parliamentarian or
parliamentarian.
Parliamentarian. Yeah. So big word, but 30 minutes on YouTube, you'll understand Robert's rules and the basics, and you'll be good at that.
And if you don't, I've got a great handout that's 2 8.5 by 11 sheets with a chart, and it's probably 85% of what you need to know to run a successful meeting. I'll email that to you, Jens, and anybody that asks for it, you can get to them.
Awesome. Yep. And then, I'm going to jump. Let's see. Understanding the vote. We talked about that. So what do we need tonight? Do we need a majority? Do we need hand raised? Is it filled out ballots? So of course, have those things. 2/3 vote. Is it a vote in the negative? And what that means is, if here's our approved budget with the $2 million repair job in it, and it passes unless it's 80% voted against.
A majority,
that's a vote.
Ratification is weird.
In the negative.
Ratification is probably the only vote you will encounter where it's a negative. A majority of the owners need to vote it down. Most of the votes that we would have, other than the ratification in Washington, would be in the positive. But let me add something. I had this experience. It blew my mind. I was doing a large repair job, 20 owners. We needed a 75% vote to take out a loan. The board had the authority to do the assessment, but if we couldn't get 15 people to vote in favor of borrowing money from a bank, we couldn't do the job.
Correct.
So I get to this meeting and I have a whole like sample agenda I like to use. I don't call this the town hall brawl. I call this the meet the team meeting, right? But, you know, first the board member was going to give a brief history of how we got there. And then, the consultant was going to say, this is what's wrong with the building and this is how we fix it, and show some slides of dry rot and windows that were not properly lapped. Then the contractor was going to talk about what to expect during construction. Then I was going to talk about how we pay for it. We were going to take owner Q&A, and then we were going to vote. That's a really good, robust agenda for one of these meetings. But my client didn't like what I had to say about that. So what did they do? Board president gave, you know, a 5-minute background of why we got here and why you should vote for this. Then he called for the vote, and then he had discussion afterwards. And I was like, why the hell would you vote on it before we let the owners discuss it? Don't ever do that. You always, and this is another reason to have another good reason to have a timed agenda. Any owner that wants to speak before we vote on this is going to get 3 minutes. And we're not going to cut you off. We're not going to interrupt you. If you ask a question of the board, they'll answer it, but it'll be on your 3 minutes or 5 minutes, whatever. But you let the owners express their viewpoints, pro, con, or otherwise, and then you call for the vote. Nothing sends a worse message to the owners than making the decision or calling for the vote before they even get to discuss it. So,
all good points, but all understanding this is going to be a voting meeting. We need an agenda. We're going to have some rules. We're going to have some announcements up front. Today, we're going to do the following, and we're going to vote on this. And here's how the rules are going to run. This is what the vote's going to be like. Here's how we're going to handle this, and all other topics are, you know, taken into a different meeting.
One other thing, if it's okay.
Yeah.
Your typical owner has nowhere near the background on the project that a board member does. And so I always like to give a little speech about a yes vote means this, and a no vote means this. If you vote yes on the loan, the board's going to do the project, we're going to borrow the money, and you're going to pay a serial assessment. If you vote no on the loan, we can't do the project in this format. The board can specially assess you $25,000, but you're not going to have this option to pay over time. It's going to be, you owe $25,000 February 1st, you figure it out. Sometimes the practical impact of the vote gets lost on some of the owners in the room, and I've seen votes fail because of that. So it's really important not to just say you're voting yes or no on the loan, but if you vote yes, this happens. If you vote no, this other thing happens. Just, you know, as a board member, you get so mired in the details that you just don't lose sight of the big picture.
Yep. And and again, talk to people who have been through these meetings, and they will have tips and, you know, again, your lawyers, managers, and consultants, just to run an effective meeting. We've all been in bad meetings, and we've all realized, if only we would have had an agenda, if only we would have explained that vote better, it would have passed. And so think about that and treat it as a pre-flight. I mean, just go through the meeting, go through the thing. Here's what we're going to anticipate. And then you'll find it works really well. And so
always good to do a little practice session.
Right. And let's see, we'll keep moving here. So real life scenarios, you know, I kind of did some types of the boards, and you know, you've got the controller board member. You know, they're the know-it-all. They're always in charge. We don't need rules. We don't have money for that. We aren't going to do anything. Catch me if you can. You know, kind of that personality. The I didn't know is a really interesting and kind of dangerous one right now. And half the time we see them as a super busy professional. They just haven't even had time to get their teeth into what's going on. They're too busy. There's no time. They end up kind of coming across as asleep at the wheel, and they don't mean to screw it up. some of them just didn't do their homework, but we're seeing a lot that they didn't have time to take on this board responsibility, and then you really kind of get messed up. The no filter, it's no document troll, total chaos, makes promises everywhere and stirs the pot. So we can the penny pincher thinks lawyers, consultants, and managers, and even insurance is too expensive. So just watch out for those kind of, red flags. But kind of our actions as we try to wrap this up. I know we're going long, but we're getting a lot more questions in there. Get your questions into the Q&A. So here's how to stay out of it. So by, no communication or having lots of communication, having that transparency, making sure that the owners understand what's going on, disclosing, staying out of that trouble, documenting things properly. And then, it really gets back to this: without a vision, the people will perish. I mean, we're going to set a vision for this community, and it's, here's who we want to be. Here's what we have to do. We've woken up and we have these problems. Here's how we're going to get out of it. And this is the way we're heading. And I know it might be expensive, and I know it might be disruptive, but here's the community we want to live in. And if you don't want to live in that community, move out. If you don't want to pay the assessment, move out.
Well, the board sets the tone.
Yes.
Because people tend to imitate what they see.
Yes.
So if the board is up there having a civil, respectful discourse, right? They don't all agree, right? Some of the people want to do the job, some of the people don't, but they're not attacking each other's character. They're not calling each other names. They're not threatening to sue each other.
Right.
That sets the tone that the organization is professionally run.
Mm-hmm.
If, on the other hand, you have board members yelling at each other, if you have them call for the vote and, 4 of them vote yes and 1 of them voted no, and then the guy that voted no is making wisecracks and undermining the decision of the majority, that sets a tone in the community. So, I mean, you have responsibilities as a board member, but they don't start and stop with decisions. The way that you interact with your board members sets a tone in the community.
Right. And I think getting your community members to feel like they made those decisions, because you're leading them through this process. And that's really one of the secrets there. So anything else to add to the kind of the real life things? We're moving into the Q&A now, I think. We've covered a lot of stuff, and
we covered a lot of ground, maybe too much, but
but it's a deep topic. We want you to stay out of claims and litigation, and most you don't get too wrapped up into it. And so it's good to see. So anyway, is any of this sounding familiar? Give me a call. We've got a quick link there for you to set up a free 15-minute call with me to get advice about your building. And you can use the QR code. You can use your phone to scan that. But
follow Jens on Instagram. He always cooks something fancy in a exotic locale. My favorite is the episode on radiator cooked fajitas. I had to get my joke in there, Jens.
Yeah, you bet. J2 is all over everything, and of course you can search for me on Instagram and Facebook and those places as well. So let's get over to the Q&A. Okay, let's jump over to here. Q&A. We got 5 questions. All right, and these don't have to be about the show. These can also bring your question, and we can get on that. So let's see. How can we get AC contractors to pick up and take old and surplus AC parts, especially metal materials that are left on flat rooftops that get impeded into the roof and cause leaks? Yeah, I see it all the time. You're talking about rooftop units. There's, reaches into his bag to get a screw and 4 others fall out. And then he steps on those screws and the screws puncture the membrane. Or replacing fan hoods, he just leaves it up there, leaves the old one up there. I think they think that nobody's up there to see the roof, and they can just kind of leave their debris up there, or maybe it's too hard to get down and that wasn't in their bid or something. But making sure, write that into the contract. All old material will be taken off and the roof membrane will be protected from puncture and abuse. And
Now,
then have us.
Are these AC units being installed by somebody that the HOA has hired, or are they being installed by different contractors that different owners have hired? I think the answer to this question is different in those scenarios. What I see a lot is the rooftop mounted HVAC. So what I see a lot is the TPO flat roof is a common element and the association maintains it. And then you've got these limited common element pads with the AC units on top. And then you have owners onesie twosie hiring different AC contractors, then come up on the roof and they're not roofers and the screws fall out of their bag or whatever. If it's that you have different AC contractors coming on the roof causing damage to your roof, there's a couple things you can do about that. Am I okay to answer this, Jens?
Yeah, absolutely. And one thing you're referring to is, hey, I want to put a downdraft super range hood in my unit. So I'm going to have my kitchen contractor go up to the roof and do some ductwork, or I'm going to add an AC or heat pump to my unit. And I'm going to go up to the roof and do my guy's going to be on our roof. And so
this is an architectural review issue that's particular to condos.
Yep.
And you as a board or a manager can control a lot of this in the course of approving the application. So the first and most important thing is you got to get your roof inspected periodically because it's a really expensive building system. And if somebody's on that roof that the HOA didn't hire that's causing damage, the sooner you know about it, the better. Right, Jens?
Yep.
The second thing is when an owner submits an application for that, hood, that vent for their range exhaust or whatever you just said it, Jens. It's been a long day.
Their jacuzzi.
Their jacuzzi or their AC. You can approve the application with conditions. One of the conditions should be that the contractor lists the association as an additional insured on their liability for both ongoing and completed operations.
Yes.
And I'm not going to go into the weeds on that, but that means that if they damage your roof, you can file a claim on their insurance, not the building's insurance.
Yep.
The other thing is a lot of associations have chargeback provisions. So if you send a vendor onto the roof and they damage the roof and the association has to pay for repairs to the roof, you can assess the owner who was negligent in managing their contractor the cost of repairing that roof. So there are some things that you can do, but they start and stop with inspecting the roof frequently. And a lot of my clients that have these rooftop mounted HVAC systems, they do a before inspection and an after inspection. And that's how they identify problems. Sorry to go on and on, but it's an interesting question.
it's a good delineation between those two things. And a couple of things I'll add. If you're having J2 do a spring and fall inspection for you, we're going to be up there every 6 months. But it's also, I've read a lot of bylaws that don't have that chargeback provision. So call Jason and he can help you put that into there. So I think we answered that. The next one's funny. What if I already panicked and deleted all my records as you were talking? Well, I feel for you because I do want some of my records. I do want
those
plans.
Is anything ever really completely deleted anymore? I'm not sure that it is.
And then that too. So we're just going to have to work harder digging through your cell phone records. So thanks for that. How likely is it that any HOA will get subpoenaed in their lifetime? Oh, interesting question. A lot of my clients get that. Yeah.
So, it's rare that you would get a subpoena because again, a subpoena is when a non-party gets a demand for information or testimony. It is more frequent that an HOA is involved in some sort of litigation and a representative has to provide testimony or documents. But I've had HOAs get subpoenaed in like plumbing class action lawsuits where the plumbing contractor that's getting sued asked for some records because they found out that building happened to have that particular plumbing system. It happens once in a while, but not super often.
Yeah. Okay. Next question. Do we always have the right to turn people away from a meeting if they don't live there? Good question.
Simple
What?
answer. No.
No.
Okay, a little more information. So there isn't a lot of case law anywhere, Oregon, Washington, or around the country about who can and can't attend an HOA meeting. But you can adopt a rule that prohibits media attendance.
Okay.
You can always adjourn the meeting if someone is there that you don't want to be there. You can adjourn the meeting and schedule it for another time when your lawyer can be there, or when this person that's showing up isn't going to be there. With regard to the people that are in this gray area, like brother-in-law, like mom and dad are elderly and have poor hearing, and the son doesn't live there, but he's there with them. I like to err on the side of generosity. I like to let those people stay at the meeting right up until the point where they're disrupting board business. And then I kick them out. I even, sometimes have a conversation with them. Like they do the sign in, they don't own the unit. I say, look, mom and dad are elderly. I understand you're their caretaker. But you can't get out of hand in this meeting. If you do, we're going to kick you out. The reason I say no is because a lawyer can't turn a lawyer away from a meeting. If they represent an owner, they have a right to be there. They're that person's attorney. In fact, somebody that holds a valid power of attorney over real estate matters for an owner has a right to be there. So some of those people you can't turn away, but the media you can turn away. And somebody that isn't a lawyer or doesn't have a power of attorney, I usually like to let them stay right up until the point where they're disruptive.
What about, and the next question asks resident. And so I'm careful about owner versus tenant.
Resident. Yeah.
Resident. And so I just live there. Yeah. I'm not an owner. And so what about residents or tenants? I guess, part of me says, well, I want them involved to understand what's going to be happening, but I'm not going to be asking for their vote, or they don't have a right to vote. And so, and like you said, as long as they're not interrupting or disrupting the meeting.
Tenants get a really bad rap in condos and HOAs. There are some bad tenants, right? It's inherently a more transactional relationship because they don't own there. They're just renting there. It's shorter term.
Right.
And so there's this perception among a lot of board members that tenants don't care about the property. In my experience, most tenants like living there.
Yeah.
And in some cases, they're just as respectful and clean as your owners, and in some cases more. So there are bad tenants. There are also bad owners. And so I like to let them attend. Like let's say you're replumbing your building or something, and that you have a long-term tenant, someone that's lived there for 5 years, loves living there, knows their neighbors. They got they don't have a legal right to be at the meeting, but you want them there because it's going to be disruptive and they're a member of the community. I just like to be clear about you don't get to vote. If you want to have your 3 minutes and ask a few questions about what to expect during construction, I usually allow that because it's just the classy right thing to do. And you want the tenant to feel like they're a member of the community, but they don't get to vote.
Right. Yep. Okay. And the last question is, let's see. I'm reading through the chat real fast.
You politely make sure that they don't vote.
We just got another one. As a resident, what are my options if I'm not asked for input before a major vote? That's interesting.
Well, so there's two different answers, and it depends on what you mean by resident.
So let's say as an owner, what are my options if I'm not asked for input?
Well,
major vote.
So if it's a board decision, then you really don't have a right to have input because only the board gets to vote, make motions, call seconds, call points of orders on a board decision.
Okay.
If it's an owner decision, and this is I don't want to get too technical with Robert's Rules of Order, but this is a Robert's Rules of Order thing. If it's an owner vote and you're in an owner's meeting and it takes 2/3 of the owners to authorize the special assessment, you absolutely have a right to be recognized and debate the motion and cast your vote on an owner decision. And if it is an owner decision and you're in an owner meeting and the board is not allowing you to make a comment, you can call a point of order. And a point of order is one of the mechanisms under Robert's Rules of Order that allows you to challenge the procedural steps in the meeting. And so let's say you say, point of order, Mr. Chair, I would like to be recognized as an owner before we call for an owner vote. And the chair says, I'm not recognizing you. And then what do? You ask for an appeal. So the chair generally gets to decide points of orders. They're the initial decision maker, to use the term from your industry, Jens.
Mm-hmm.
But if there's an appeal, then the assembly, all of the owners that are there, get to decide, fully and finally by a majority vote, whether you get to speak or not. So you could call for an appeal. So that's if you're an owner. If you're a tenant, you really don't have a legal right to provide input. But again, there's what you have the legal right to do, and then there's what is good politics, what is good community building. Right. And when I'm chairing these meetings, if there's a long-term tenant, somebody that cares, somebody that's obviously respectful and not going to be disruptive, I always encourage the board to let them say a few words because it's just the right thing to do.
Yep. Okay, last question. How do you politely make sure they don't vote? Ooh.
Well, you don't have to be polite about it. So, I mean, in a owner's meeting, because in a board meeting, only the 3 or 5 or 7 board members get to vote. And if they're sitting at the front of the room, everybody knows who they are. And when you call for the vote, if you're recording the votes of the directors and somebody in the audience wants to cast their vote, it's painfully obvious to everyone in the room that the person in the audience doesn't have a right to vote. So that doesn't usually happen. But sometimes you have a tenant show up to a meeting and want to vote. And the way you deal with that is with a sign-in sheet. And sometimes it's a sign-in sheet, and as people sign in and you verify that they're on the owner roster, you hand them their ballot. And so you know that the only people in the room that have ballots are people that actually live there and they're members of the association, they get to vote. The other way to do a vote is, this is a fancy term, right? A viva voce vote, which is just a fancy way of saying roll call.
Right.
So
gotcha. Yep.
Everybody signs in at the meeting. And so you know who's there in person and by proxy. And I've done this over Zoom lots of times. I have a condo hotel client. I run their annual meeting for years, and a bunch of people show up to the meeting. I know who's there after sign-in. And then we go down the list. Okay, Jane Doe, how do you vote? Yay or nay? Joe Schmo, pull yourself off mute. How do you vote? Yay or nay? I was going to say this earlier, but I have also seen some associations that meet over Zoom use the polling feature to vote. Although that's a little fraught because you could potentially have somebody on the call that casts their vote that isn't an owner. And that's why it's triply important that you do a sign-in sheet or a roll call vote.
Gotcha.
So you don't really need to be polite about it. It's just you never ask them to cast their vote because you're going down the list. You either gave them a ballot or you didn't, or you're going down the list and you're recording their verbal vote.
Gotcha.
And if they insist on voting, you can politely say, well, I'm sorry, you're not an owner. And so we're happy to have you here, but we're not going to record your vote. XOXO JLG.
Viva voce. Okay.
Viva voce.
All right. Great questions, everybody. We are long, so thank you so much for your patience sticking in there. Giveaway time. We have some giveaways. Let's see. I know J2 is putting out it's cold out, so we got a J2 beanie. We got a thermos coffee mug. We've got a package of coffee in there, J2 brew, and some other good little trinkets. And how we do this, Jason, is we pick a number between 1 and 10. I'm going to pick I don't know, 5. So then what's your giveaway? And then you pick that same kind of number between 1 and 10. And
So mine's nowhere near that fancy. Mine's just a $50 Amazon gift card, but I need your email to email it to you.
gotcha.
So is there a way to get this person's email?
So what Ben does is he sees a list of all the participants, and then he sees that number 5 that I picked. So you pick that number and he will reach out and get their email and get that to you, and then you can send it to him.
Then I'll make sure that you get your gift card. Okay, I'm going to pick lucky number 7.
Lucky number 7. All right, there we go. Thanks for playing. Did you know we have free resources for boards and managers? Check it out. learn.j2consultants.com/resources. Over 300 videos out there. Stream this webinar wherever you go. We're on iTunes and whatever the podcast things are out there. And don't forget, we'll be back live each month. We traditionally do this on the last Tuesday of every month. Last Tuesday of December is going to be Christmas week. So we're going to have a really good best of 2023. And stay tuned for that. You'll get the recaps, and Jason might make it because this was actually a really good one. But thank you, Jason. Me. Yeah, thank you for attending. You gave us lots of great information. You're always a pleasure to talk to. Everybody in the audience realizes that you have a lot of experience, and so reach out to Jason if you have these questions. And again, feel free to reach out to me, and we can steer you in that right direction. So thank you again, Jason. Do you have any closing words?
No, thanks for having me. A great crowd, and we'll talk to you soon.
All right. Thank you so much, everybody. Good night.